What's up, everyone? It's Mikey T, the movie star, back for another Report Card Radio exclusive. Just when you think, you're starting to understand everything, everything just took a 360-degree spin for me right here, guys. Like, we're on a whole nother track right now from what I'm reading. Today, we're going to go over some important information. I had a whole nother line that I was going to go down today, but this is a breaking news story. Apparently, Arab had the same lawyer as Taz. He had the same lawyer. Arab had the same lawyer as Dontez Stewart, and that's the information that I'm bringing everybody today. This is crazy when I'm thinking about it. It just screams conflict of interest to me, and that's actually what we're going to be reading today. It's the United States District Court for the Eastern District of Pennsylvania, the United States of America versus Abdul West, Jamal Blanding, Jamal Hickson, Richard Chase Hoover, Dontez Stewart, Amir Boyer, Daryl Baker, Heinz Gadsden, and Dennis Harmon. Criminal action number 18-249. This is a memorandum, attorney conflict of interest, dated March 15, 2019, Bayless and J. In this criminal case involving allegations of conspiracy to distribute controlled substances, the government has filed a motion to disqualify an attorney, Edward Meechan, from his representation of Abdul West. The government asserts that the conflict arises out of Meechan's prior representation of several of West's co-defendants, including, in relevant part, Dennis Harmon and Dontez Stewart. So it's right there. It's right in the first paragraph. It's an attorney conflict of interest. Arab had the same attorney that represented Dontez Stewart. So we're going to get into this whole thing today. And here they give Ab a couple chances to dismiss the lawyer. As we all know, a few days ago, I read Ab's lawyer's cross-examination with Taz. He didn't end up using Mr. Meechan, but let's read in and see more about this story. With regard to the three defendants at issue in this matter, the indictment alleges that West was the leader of the drug trafficking organization, that Harmon was, along with others, responsible for staying with and protecting controlled substances supplies kept at the various residencies owned and maintained by West and others, and that Stewart, along with others, distribute controlled substances in and around Philadelphia. Following a pretrial hearing on February 19, 2019, we issued an order that the government's motion to disqualify Meechan is denied. The memorandum further explains that conclusion. Before we get to the memorandum, the government also states that there is a conflict of interest resulting from Meechan's prior representation of Amir Boyle and Daryl Baker. And Amir Boyle and Daryl Baker, that is Mullah and Shadi, so Ab's younger brother, and Shadi, who I want to say was mentioned earlier. Shadi was mentioned earlier in the case, but it was spelled S-H-A-D-A, I believe. This one is spelled Shadi in the indictment. Probably the same people. I never met either of them. I had met Mullah on a couple occasions. Really cool dude. He was really, to me, he was building the under part of the label. He had told me, Mikey T, it'd be dope if you could come out and interview a couple of the other artists on OBH aside from Ab and Dark Low and Leak Moss, because as I had stated before, OBH had a thriving young roster, No Breaks Bras, among others. So the government's motion to disqualify Meechan. The government filed its motion for a hearing regarding attorneys' conflict of interest on December 6, 2018. In that memorandum, the government outlined its position that Meechan faced conflicts of interest because of his current and former representation of other defendants in this case. The government argues that Meechan is conflicted because of his prior representation of Harmon in a state case for possession with intent to distribute, PWID, possession with intent to distribute. Interesting. Controlled substances on September 11, 2017 at 3234 Sydenham Street. This address is the superseding indictment as one of the properties from which the drug trafficking operation was managed. The charges in that state case were adopted in the superseding indictment, and West and Harmon are now both charged with PWID narcotics found at the Sydenham address on September 11, 2017. So this is the house that got raided, and now they're both charged in connection in the same, because Ab most likely owned the property, is why Ab is getting charged. This is what I've said before. Ab's getting charged because he simply owns a property. If one of my friends started renting properties and he managed 10 estates and 2 or 3 of the people were living illegally, I don't think that should fall on the landlord. The landlord's managing 10 estates. He's got other things going on in that 30-day period during the month. The government also argues that Meechin is conflicted because of his representation of Stewart in a gun case currently pending before the Philadelphia Court of Common Pleas. At the argument on December 13, 2018, Meechin stated that he withdrew from the case on December 4, 2018, because the government was filing a motion. As far as my representation of Mr. West, I've represented Mr. West for a number of years now, because the gun case had been consolidated with a murder case involving that gun, so Mr. Mendel was already representing Stewart on the murder case. So Mr. Meechin actually broke that down there, so if anybody throughout the rest of this is wondering why Ab would want to stick with Mr. Meechin as his lawyer, even though it's coming out that Taz also had him for a gun charge, Mr. Meechin and A.R. Ab apparently worked together for a number of years. So let me read this back. The government also argues that Meechin is conflicted because of his representation of Stewart in a gun case currently pending before the Philadelphia court. At the argument on December 13th, 2018, Meechin stated that he withdrew from that case on December 4th because the government was filing a motion as far as my representation of Mr. West. And I've represented Mr. West for a number of years now. And because the gun case had been consolidated with a murder case involving that gun, so Mr. Mendel was already representing Stewart on that case. You should all get that right there. That's pretty much in the proof is in the pudding right there. Everybody who was wondering about that gun that was used, this is how it all ties in. So Mr. Meechin was actually excused. The government excused Mr. Meechin. So the government contends that this prior representation would cause Meechin's loyalties to be so deeply divided between his current and former clients that he could not conform with the rules of professional conduct, and thus disqualification would be warranted. Over the following 2 months, the government filed 2 supplementary memoranda. Among other things, the government argued that a statement by Meechin at the December 13, 2018 hearing that West asked him to speak with Harmon makes Meechin a potential witness to the conspiracy. The government later clarified on a telephone call that it is not suggesting in any way that Mr. Meechin was a part of this conspiracy or has done anything untowards or unprofessional. So then we got the procedural history. Upon receipt of the government's request for a hearing on this matter, the court heard argument from the government and Meechin on December 13, 2018. The court entered into a colloquy with West, where West stated his understanding of the potential conflict and his intention to continue with Mr. Meechin's representation. Ann Flannery, counsel for Harmon, was present and was directed to determine if Harmon intended to waive his conflict. Such a waiver was provided to the court on January 11, 2018. On a recorded telephone conference on January 17, 2018, the court discussed with the parties the need for a waiver from Stewart. The court also took government counsel's suggestion that West consult with a conflict-free counsel on February 5, 2019, appointed Jonathan Feinberg, to meet with and advise West of the potential conflict of interest with this chosen counsel. On February 12, 2019, the court held a hearing at the request of Stewart's counsel, Trayvon Borum. A portion of this hearing was on the record with the government present, a portion was off the record without the government, and a portion was off the record with only the government present. Very interesting right there. So Taz has another lawyer. Taz is meeting with the government on this date, February 12, 2019. So a portion was on the record, a portion was off the record, and there was a portion with only the government present. You can read between the lines. So a summary of this hearing is filed in a separate sealed memorandum. Stewart did not provide a waiver of any potential conflict. That's because he knew he didn't need a waiver at that point. He knew he was going to, as he said on the stand, that man right there has my future in his hands. On February 15, 2019, the court held a hearing where it entered into second colloquy with West and Meechin and Feinberg were present. The court asked questions of West and Meechin, particularly about Meechin's former representation of Stewart in the gun case and what information Meechin may have obtained during the representation. The court explained in detail to West the potential conflicts that might arise. West replied that he understood all the risks, but wanted Meechin to represent him. West was given an opportunity to speak independently. Both Meechin and Feinberg were. West was given an opportunity to speak independently with both Meechin and Feinberg. So then this is the report of conflict-free counsel. Feinberg filed 2 reports on February 19, 2019 as directed by the court. One is public and one is sealed. In the public report, Feinberg explained that he met with West twice, once at the Federal Detention Center and once during the February 15, 2019 hearing, and provided Mr. West with my professional opinion as to the potential impacts of Mr. Meechin's continued service as his counsel arising out of the conflict of interest presented by Mr. Meechin's past representation of his co-defendants. He further explained, the day Feinberg report was filed, the court held a pretrial conference and ruled that upon the consideration of Feinberg's reports, the filings and the testimony, the court would reject the government's request to disqualify Meechin from representing West. So they're going to let Ab continue on with his lawyer, even though it seems like they have a little bit of suspicion that that this lawyer who had once represented Taz, also Dennis Harmon, that he could potentially help Ab in this case. As I read earlier, there was a mention of him being thrown into the conspiracy, but I think that's quite ludicrous. The government obviously wrote him back and said, we're not going to do that. So during both encounters, Mr. West has informed me that he wishes for Mr. Meechin to remain as his counsel and that he is willing to waive the rights to challenge any further conviction based on Mr. Meechin's conflicts of interest. I believe that Mr. West understands the nature of the conflicts of interest and he appreciates the risks associated with Mr. Meechin's continued representation and that he is knowingly and voluntarily waiving the right to assert that a conflict of interest prejudiced his right to the effective assistance of counsel. So that was actually what this guy, Mr. Feinberg, had spoke with Ab about on those 2 different occasions. Ab said that he was willing to waive the right to challenge any future conviction. So part 4 is the discussion. We begin our analysis with a recognition of a presumption in favor of a defendant's choice of counsel. The presumption may be overcome not only by a demonstration of actual conflict, but by a showing of a serious potential for conflict. The evaluation of the facts and circumstances of each under this standard must be left primarily to the informed judgment of the trial court. We must weigh on one hand the client's Sixth Amendment right to counsel of their choosing, on the other hand, the right to effective representation within the professional conduct rules. Ultimately, the district court must be allowed substantial latitude in refusing waivers of conflicts of interest, not only in those rare cases where an actual conflict may be demonstrated before trial, but in the more common cases where a potential for conflict of interest exists, which may or may not burgeon into an actual conflict as the trial progresses. The first determination, therefore, is whether an actual conflict exists. Actual conflict of interest is evident if, during course of representation, the defendant's interests diverge with respect to a material, factual, or legal issue or to a course of action. The Third Circuit affirmed the district court's issuance of a writ of habeas corpus after it found that an actual conflict existed as a result of dual representation in a criminal case. That opinion came after the Supreme Court vacated an earlier decision that found only a potential conflict of interest. We hold that the possibility of conflict is insufficient to impugn a criminal conviction in the order to demonstrate a violation of his Sixth Amendment right. A defendant must establish that an actual conflict of interest adversely affected his lawyer's performance. And this is from Culler v. Sullivan. The court may disqualify an attorney even if there is a potential for conflict but no actual conflict. Should we find that an actual conflict exists, we must examine whether it is possible for all affected clients to waive their right to conflict-free counsel. Where a court justifiably finds an actual conflict of interest, there can be no doubt that it may decline proffer of waiver and insist that defendants be separately waivers that have been obtained after advice from independent counsel are best. As you saw, Ab waived his right, Taz actually waived his right. Although there is some potential for a conflict in this case, the court concludes it is minimal. And it is understood by West, and it is not serious enough to disqualify Meechin by way of example, and as discussed during West's second colloquy on February 15th, 2019. Meechin may be limited in his ability to properly advise West regarding his potential government cooperation, if doing so would potentially injure one of Meechin's former clients. Hold on, let me read that again right there. That Ab's name and cooperation just doesn't sound right together. You know what I'm saying? Ab is an honorable dude. So Meechin may be limited in his ability to properly advise West regarding his potential cooperation. So he may be limited in his ability to properly advise because Ab's not going to take no BS like that. Ab's not going into witness protection. Ab's not going into talking cooperation agreements. I haven't read one statement given to Ab. Ab could have jumped on the stand this whole time and pointed fingers, and Ab could have said, this guy Taz is the one who came around the group and brought all of this to me. Ab could have pointed the fingers at anybody he wanted to this whole time, but he's never done that. Although there is some potential for a conflict in this case, the court concludes it is minimal and is understood by West and is not serious enough to disqualify Meechin by way of example and as discussed during West's second colloquy. Meechin may be limited in his ability to properly advise West regarding his potential government cooperation. If doing so would potentially injure one of Meechin's former clients, Meechin may be also limited in his ability to cross-examine his former clients should one or more of them decide to cooperate with the government and take the stand as a witness against West. Even if they do not cooperate, one or more of Meechin's former clients may testify against West, putting Meechin in a position of cross-examination his former client. West understands the possible limits of Meechin. There is, however, no actual conflict of interest presently in Meechin's representation. We conclude that this potential for conflict is waivable and that West's waiver of potential conflict was knowing and voluntarily, and he both this court and West's two consultations with conflict-free counsel. West has stated in an open court that he understands the ways the potential conflict could play out at trial and remains steadfast in his desire to have Meechin represent him. West has stated that he understands that the potential conflict that has been waived by Harmon. Although Stewart did not make a waiver, West has also stated he understands that there may be restrictions on Meechin's ability to cross-examine Harmon and Stewart because of his prior representation of them. Nevertheless, West has repeatedly told the court that he wants Meechin as his lawyer. We conclude this was a valid waiver of the potential conflict of interest. We are not persuaded by the government that Meechin could properly be called as a witness to conspiracy. In the United States vs. Fumo, the government attempted to disqualify the defendant's attorney because the attorneys were alleged witnesses to the events relevant to the charges in the indictment. Judge Yon concluded that the situation in that case did not arise on the level of conflicts requiring disqualification, as outlined in the leading Third Circuit cases, the United States vs. Merlino, the government of Virgin Islands vs. Zepp. In Merlino, the attorney for the defendant, he had gone to visit a cooperating witness in prison, and in an attempt to persuade him not to testify, gave the witness a letter from his client stating that the mob did not intend to kill him, and offered the witness money for his commissary. Merlino, the district court, had disqualified the attorney, noting that the defendant was employing a mob denial defense at the trial, and that the attorney's visit to the witness was being presented to rebut that defense. The Third Circuit affirmed the disqualification. In Zepp, the Third Circuit found that a defendant's Sixth Amendment rights were violated when her attorney entered a statement that was proffered as evidence for the government. The attorney had arrived at the defendant's home moments after her arrest, closed the door to speak with the defendant, and then the officers heard a number of toilet flushes. The statement by the attorney was that he did not flush any toilets. The Third Circuit noted that his interest in testifying on his own behalf impaired the exercise of independent judgment on the behalf of his client. Wow. This is pretty interesting, guys, reading some of these other cases that they're using in reference to Ab's case. They have one case that I just read there about a lawyer apparently flushing drugs for a client, and then you had another mob instance where they employed a lawyer to go see somebody who was ratting and offer him money for his commissary, money when he got out of jail potentially, just so he wouldn't testify. That's a very interesting concept that they're bringing in here for terms of disqualifications. I don't think Ab should be up for that when it came to this because of the fact that he had Meechin prior to all of this. In maybe any of his other cases, he had Meechin already represented him. Even before Taz and before Harmon, Abdul West was represented by Mr. Meechin. So it's actually bringing us to a whole nother case here. As in Fumo, the potential conflict of interest at issue here does not rise on the level of being non-waivable. In both Merlino and Zepp, the attorneys were involved in the underlying offense. There is no such allegations against Meechin. It would be improper for Meechin to be called as a witness in this case based upon his statement in the court. West asked Meechin to visit his friend in jail. Conclusion. Given the significant amount of discretion the court has in this area and the fact that the disqualification of Meechin would give West a possible successful argument on appeal to avoid any conviction of West by the jury, we conclude that West knowingly and voluntarily waived his right to conflict-free counsel. We therefore deny government's request that we disqualify Meechin from representing Mr. West. And this is signed by the court. That's right. So It would be improper for Meechin to be called as a witness in this case, based upon his statement in court that West asked Meechin to visit his friend in jail. Very interesting note right there at the end. And the conclusion is that the government is going to allow Arab to continue on as he has knowingly and voluntarily waived his right to conflict-free counsel. So the government pretty much was telling Ab, I think they were like, we hope you have some issues when it comes to, this whole case. We hope that your lawyer isn't able to cross-examine any potential witnesses that we have to put on the stand because it would be a conflict of interest. So I want everybody to just stay tuned because I originally had another exclusive and it's pretty dope because I think that story actually plays into this one. So I'm glad I actually got this one out first for y'all. Everybody, if you would just subscribe on the YouTube here, Report Card Radio. Follow me on Instagram at MikeyT_the movie star. Everybody who follows me, I'm following y'all back. If y'all stay tuned for this 25 minutes, follow me. I'm following you back. Everybody on the gram right now. And if anybody wants to send a donation to the channel, which we respect, anything is It's all love. Anything you want to send to the Cash App is all love. It's Mikey T Movie. MIKEYT Movie on the Cash App. I'll leave a right in the description. Hit the like button, share. I appreciate y'all, man. Mikey T the Movie Star, signing out.